Well, hey kids, how are you? Today we're going to talk about defenses to some of these crimes that you've been learning about. You learned about crimes against people and things like murder and rape and assault and a variety of other things. You learned about crimes against properties like embezzlement, theft, arson, and some other things. It's important that you understand that just because you're charged with a crime doesn't mean that you're going to be convicted. If you decide to go to trial, then your defense team, your lawyer with your assistants, should be looking at a variety of different ways to defend you. And there are defenses for crimes that you get charged with. So we're going to talk about those defenses. I have a PowerPoint set up here. I'm going to go through it in the order that the chapter does for you to make it as easy for you to follow along as possible. I'll tell a few stories like I do in class. I won't use the same kind of terrible examples that I use in class, but I will have some stories for you. Okay, so the first thing that we have to look at is that there's defenses to all kinds of things. One of those defenses that we will talk about is necessity. We're going to get there at the end, but you ought to take a look at who Oliver Cromwell is and why he would have said that necessity has no law. It is important for you to understand that that these defenses are all really, really important. I will put the PowerPoint up so that you have a chance to see it. I'm going to move my screen up there so that you have a chance to see it and go through it on your own. Remember, just because you're charged with a crime doesn't mean you have to be convicted. There are defenses. One of the things you do have to pay attention to, though, not all defenses will work for all crimes. It's important for you to note that. Okay. So let's start with where they start in the book, and they talk about where no criminal act was actually committed. There have been cases of people who are charged with murder or charged with other offenses where actually no crime has been committed. If you were charged with murder and the person that you supposedly murdered walked into the courtroom in the middle of your trial, it would be hard for them to prove that you actually committed a murder in any sense of the word. So if no criminal act has been committed, that is absolutely a defense for a crime, whether it's an assault, whether it's a rape, a theft, any of those kinds of things. If you haven't actually done anything wrong, well, it's kind of hard to convict you, although certainly people have been convicted of crimes they didn't commit. In this case, we're not talking about a crime happened and we got the wrong person. What we're talking about is that no crime actually happened. And it's important to note that. No crime actually happened. And that's why nothing would go happen to you. The other one is when actually you didn't have an intent to commit a crime. And there's a couple of things that go with this. There's a mistake of the law. There's alibi. You weren't. I'm sorry. I'm moving ahead. With no criminal intent, the mistake is that you didn't know it was illegal. You didn't, and ignorance is not usually a defense here. But when you're mistaken as to what the law is in good faith, as long as it's not a violent crime, oftentimes that defense will go along with it. It really goes back to that thing that we talked about early on, that you have to have mens rea. You have to have that guilty state of mind where you did it intentionally, where you did did the act willfully, where you did it knowingly. If you aren't doing these things knowingly, intentionally, willfully, and there's no mens rea, there's no criminal intent, and that's important to pay attention to. Okay? This is where I was jumping ahead to. If you didn't actually commit the crime, but a crime has been committed, so somebody has been killed, somebody has been raped or assaulted, there was a theft, there was an arson, there was something done, and that something that was done is fairly significant, you might not be guilty of it if you didn't actually do it. If you have evidence that shows you were someplace else, there's video of you at a basketball game or a football game. There's several witnesses that'll corroborate a story that says you're someplace else. Then you have what's called an alibi. You have proof that you didn't commit this crime because you were not involved in the commission of this crime. It is important for you to realize, though, that alibi doesn't work when you helped to plan it, when you did any of those inchoate crimes like soliciting it. If you solicit the crime, if you solicit somebody's murder because they were cheating on you, just because you weren't there doesn't mean you're not guilty of the crime. Not being there in that case isn't an alibi. Not being there in that case is simply part of the act of the crime. Since 1984, 1985, we've had this influx of DNA evidence that happens. And where there is DNA evidence, if your DNA doesn't match, that probably shows that you didn't do it. But one of the things to be careful of is that DNA evidence is unreliable. Most people think of it as incontrovertible proof of somebody's commission of a crime, when in fact it's not necessarily that way. If the DNA shows that you were on the scene, it simply shows that you were on the scene, not that you actually did something. The exception to that might be in a rape case where the DNA is found from the sperm inside the vagina of a woman and there's no other DNA in there, then that might be evidence that at least sexual intercourse happened. It doesn't prove that there wasn't consent. It doesn't prove that it was a non-consensual act. All it proves is that the person was there. And so we have to pay attention to that. However, if there's DNA evidence inside of that woman's vagina and it is not yours, it is going to be awfully hard to convict you for that crime, assuming that a crime has actually occurred there. So, what if you actually did do the act? What if all of the elements of the crime, or at least the majority of the elements, are there? There's a dead body. There's a woman who's been raped. There's evidence of somebody having burglarized a house. There's a burned down house. There's a variety of things going on, and somebody absolutely did something. And you're the person that actually did whatever it is, you might not be guilty of a crime necessarily if you have what are called affirmative defenses. An affirmative defense is when you say, yeah, look, I did all these things. I took this person's life. I did this, I did that. I robbed that store, I robbed the bank. I kicked the dog, I hit that person. There might be reasons that you would not be held criminally liable for those types of acts. So some of them are pursuing excusability, justifiability of your acts. An excusable or justifiable act means, yep, I did this. I killed that person, but I should be excused from criminal liability because I should be excused from criminal liability because it's justified. Self-defense. If somebody's coming after you with a gun and you shoot them dead, it's going to be hard to convict you of that crime if you are claiming self-defense. Now, you can't have been going after them first and they were defending themselves. That's not quite the same thing. It's also important to understand that self-defense in the form of fighting is probably the most misunderstood concept. A lot of you think that somebody is saying, come on, let's go, when you throw up your hands and you're like, all right, come on, bring it on, that's self-defense. No, that is not self-defense. That is, in fact, engaging in the fight. And by engaging in the fight, both you and the other person, you're both going to be guilty of assault in any criminal court. It happens that way in school. It happens that way at Judge Muth's courtroom. It would happen that way in the courtrooms over at the Stroud Mall, at the Stroudsburg, at the Stroudsburg courthouse. All of them are going to do that same thing. You cannot use self-defense simply because you decide you want to get into the fight. Bringing it on isn't self-defense. Self-defense is using enough force to get them out of the way so you can escape the situation. That's what self-defense is. Pennsylvania doesn't have the stand your ground law. That means that you can't just be out on the street and somebody comes after you and you go, okay, come on, bring it on, and be able to use deadly force. That's not acceptable in this state. You can only use enough force to escape the situation. If that force happens to be deadly force, that's okay. But if that force only needs to be you pushing them out of the way so that you can run the other way, then that's what you need to do. Because otherwise you're going to be found guilty of a crime, and self-defense is not going to cut it in the court of law. Pennsylvania, however, does have a castle doctrine. That means that when you're at home, when you're in your car, when you're at work, there's no need for you to have to back away, to back down, to retreat. You can defend yourself and your property using appropriate force. There's no reason that you have to back away. Okay, so you don't need to retreat from the attacker, but you cannot defense an action whereby somebody comes onto your property looking for their baseball and call it the castle doctrine because you're afraid for your life that their baseball is under your bush. That's not a defensible act. Okay, it's not even a mistake. So that's not something that you can claim. If we get away from justifiable and excusable acts, then we start getting into things like infancy. Young kids, think about when you were young. When did you start to know the difference between right and wrong? When did you start to know that Bugs Bunny wouldn't actually come back to life in the next scene when the dynamite blew up in his face? When did you start to actually realize the consequences of actions, the morality of actions, that basic idea of right and wrong? In the legal sense, we tend to use age 7. At age 7, somebody that commits a crime may or may not be charged with it as an adult. At age 6, they almost never will. We tend to use 6 and under age 7, as a bright line, this line of demarcation where we say, yeah, kids this age don't really know the difference. We're not going to hold them criminally liable for their actions. We might hold them juvenilely liable, and juvenile liability is different than criminal liability. A juvenile delinquent is a delinquent until they're 18, and then they're an adult. And if they do those same acts later, they could be tried as an adult. But we have this defense of infancy, and sometimes it's by age and sometimes it's by intellect, because there are people who are 30 years old but will never be older mentally than a 5-year-old. They're never going to have the mens rea. They're never going to have a guilty state of mind that we can use to talk about committing a crime. Okay, and so the infancy defense is pretty much always going to play in there. This is why we have juvenile laws, because infancy can be somewhat controversial. There was a case a few years ago. There was a kid, 14 years old, who raped a younger girl, and the district attorney wanted the judge to disallow an infancy defense, whereas his lawyer wanted the defense to be able to use infancy, because they thought he didn't understand the difference and shouldn't be held criminally liable as an adult and face those lifelong consequences that would come with it. The Pennsylvania Supreme Court actually did not make a ruling. It's a pretty interesting case to read about. One of the names, I think, is Martz, M-A-R-T-Z. If you want to, you should go take a look at that. Intoxication. Okay, there's voluntary intoxication and involuntary intoxication. Involuntary intoxication almost always allows you a defense for the acts that you do because you got drunk or high without your knowledge and consent. It means somebody spiked your drink, somebody put a Mickey in your drink, somebody gave you something they shouldn't have given you. If you have allergies to things and they know that and they're able to intoxicate you pretty quickly, then that's almost always a defense, because when you get that drunk, that high, and you didn't know you were getting that drunk or that high, well, your acts, you've lost the ability to think. How do you form a guilty state of mind? How do you intend to commit a crime? So we're going to talk more about voluntary intoxication. You're the one drinking the drink. You're the one injecting the drug, smoking the weed, whatever it is, you're the one doing it. If you get so drunk that you do not know what you are doing, there are a few crimes here and there that it might actually be a defense for, because intoxication, voluntary intoxication, is rarely a defense for a crime. However, you're wasted. You were at a party and you got terribly drunk. And you walked into a store because you're hungry, and you picked up a bag of chips, and you are so drunk you're out of your mind. You walk out of that store without paying for it when you didn't really intend to steal it. You're just thinking about food. Your intoxication might actually be a defense. It's not going to be a defense where there's personal injury or violence involved. We're pretty much going to be talking about property crimes. But if you're drunk enough that you fell over somebody's bush and broke it, there's no criminal intent. There might be civil liability, but probably not criminal liability. So that's where that becomes a defense. We're talking about typically minor crimes. It could be a minor crime that has a high dollar value, or a minor incident that has a high dollar value. If it's a minor incident with a high dollar value, certainly someone's going to come after you civilly, but the criminal courts will probably beg away from that, knowing that you're going to have a viable defense because you didn't form the intent. Intoxication is never a defense when you get drunk enough to do something. So I'm mad at Trevon that today was TikTok Tuesday. I don't do TikTok. And so I decide that I just need to kill him because TikTok Tuesday makes me murderous. And I'm wearing denim today, so I'm even more murderous. And I'm a bit of a coward. And so I choose to go into the liquor cabinet and drink a big bottle of booze to work up the courage so that I can plan his murder. And I'm looking at a banana peel on my desk. So I'm going to plan a murder by banana peel because I'm going to throw it down in front of him and he's going to fall and he's going to hit his head, and that's how it's going to happen. Yep, that's what I'm going to do, but I got to get drunk to do it. Yeah, my intoxication's not going to be a defense. I already had the criminal intent before I got drunk. See, this is where the intoxication plays in. It's when do you form criminal intent? Did I form it before or after I got drunk? And if I formed it after I got drunk, could I really form that intent? That's the question. Insanity. Okay, insanity is a contrivance of the law. Insanity is not a psychological term. You never get diagnosed as insane. You are declared insane by courts. So insanity is all about law. Okay? Insanity is important 3 times during a criminal case. The first time is at the time of the act, when the crime happened. Did it happen? Is it a murder? Is it is it? I don't want to use rape because it's hard to use insanity for rape. Is it a theft? Is it an assault? What's the crime? And was the criminal mentally with it when that happened? And there are lots of cases. There's this phenomenal case, and a movie was made out of it. The movie is called A Beautiful Mind, and it's based on the life of a brilliant mathematician by the name of John Nash, who is schizophrenic. The guy hallucinates friends. He became, in his head, a code breaker for the CIA, and was able to find all kinds of plots and controversies going on, and he gets involved in a variety of things, and he's committing crimes along the way, thinking that what he's doing is perfectly appropriate and sanctioned by the FBI, the CIA, whoever it is, only to find out that he's imagining all of it in his head. They put him on drugs to help manage it. And in the end of the movie, he gets rid of the drugs because part of his genius in mathematics is his schizophrenia, the ability to look at the world through slightly different lenses. He has to be very careful not to commit crimes based on these hallucinatory friends that he's known in his head for a very long time. So if you get a chance, you ought to look it up. But these are the kinds of things that the courts use to define insanity at the time of the crime. Are you suffering from some mental incapacity, from some deficiency that forces you or allows you to believe that what you're doing is okay and correct? That's the first time. The second time, someone needs to have mental capacity to stand trial. If they are not mentally capable of understanding what they did, understanding what the proceedings are, and helping in the proceedings of a criminal trial, then that trial will be postponed until that person gets medical treatment sufficient to help them become sane for trial. If they've gone through the trial, they were declared sane for the trial, but the jury or the judge thinks they're not quite right. One of the things that might happen is they'll worry about the sanity after the trial. Sanity after the trial goes with this. It goes with a verdict of guilty but mentally ill, okay? Or guilty by reason of mental insufficiency, or mental defect, or there's a bunch of different ways that we say this. This is where they think that the person was guilty of the crime. They did everything they needed to do to commit the crime, and they were sane In other words, they were able to form the mens rea at the time of the crime. But if now at sentencing they're not able, if during the trial they're not able to deal with it, we can get a guilty but mentally ill verdict. And what that'll do is, instead of going to jail and being in general population, they'll go to jail in a psych ward. They'll go to jail in a psychiatric hospital. That is where they will be kept under lock and key and given medical treatment until such time as they can serve the rest of their sentence in general population. One of the most famous cases where somebody was found actually not guilty by reason of mental instability is John Hinckley. He's the guy who tried to assassinate Ronald Reagan. You should look that up. It's fascinating. It's out there on the Schoology. I think it's out there on the Schoology website. So if you want to go find that, it's pretty cool what his defense was and how that worked. And he served, I don't know, 30, 40 years in a mental institution rather than in a prison. Another one that is used quite frequently is entrapment. Entrapment is when somebody is convinced to commit a crime by the law enforcement agency that convinced them to do it. So a cop walks up to you and says, "Hey, you want to buy drugs?" You say, "No, man, I don't do drugs." "No, seriously, you're going to like this. You should try this." "No, really, I don't want to." "No, look, I'm telling you. You need to do this. This is the best thing since sliced bread. You will never view learning from home again the same way if you try this drug," and they convince you to take the drug. They didn't just ask you and offered you the opportunity. They convinced you. They said, "Hey, here's an opportunity to commit a crime. Do it, do it, do it." They persuade you. They do more than just, "Hey, you want to try these drugs?" "Yeah, man, let me do them." That's not entrapment. Okay? So the police set up stings all the time. They set up stings for prostitution, for drugs, for a variety of other crimes, solicitation of murder. So a really hot girl, a really hot guy on the street says, "Hey, baby, want a date?" And you say, "No, I'm good." And you keep going, you keep walking, you keep driving. He or she follows you. "No, seriously, come on, let's take a date. You're really cute. I'd really like to go out with you." And then you're like, "Okay, well, what do you mean?" And they say, then they start talking services and prices. And you're like, no, seriously. They bring the price down a little bit. "No, really, I don't want to." They bring the price down a little more. They keep coming after you for it. As soon as you say yes, after you've denied a couple of times, well, you're not being entrapped anymore. You're a willing participant. So entrapment is when, I'm sorry, you're being entrapped. I said that wrong. After a couple times of saying no, you're being entrapped. If you say, "Yeah, that sounds good," after the first or second ask, you're probably out looking for that, whatever the crime is. Okay. If you go out looking and you find a cop, that's not entrapment at all. That's just you being stupid because you got the wrong person and you weren't able to commit your crime because you got caught by the person who was looking to catch you without knowing it. It's when they come after you and offer it to you. The show you should watch to see what that's like, and it's not entrapment, is Bait Car. They put a really nice car out on the road. They let the keys in it. They let people walk by. Who's going to go and take a ride? Who's going to go for a joyride? Who's going to take that car? That's not entrapping. That's simply offering you an opportunity. And if you're stupid enough to take it, you're smart enough to go to jail, if that makes sense to you. Okay? Duress. Somebody knocks me out, straps a bomb to my chest, and says, "Hey, I need you to go rob that bank. If you don't rob that bank, I'm going to go and blow you up. And I have this thing about not being blown up, so I go and rob the bank." When I go and rob the bank, I'm going to stand there at the teller's window and I'm going to say, see, I have this bomb on my chest. I don't want to be doing this, but if I don't rob the bank, they're going to blow me up. So please give me all your money. And then I'm going to walk out and the CIA, not the CIA, the FBI is going to be there following me. And I'm going to say, hey, please, I don't want to blow up. Let me deliver this money. Follow me. Catch this guy. Get this bomb off of me. I don't want to die. That's what duress is. Duress is putting somebody in a situation that is out of their control. It's saying that we're going to hurt you, we're going to hurt your friends, we're going to hurt your family, we're going to kill your pets unless you do certain things. Now, you got to be careful. I can't hold a gun to you and tell you to shoot the person to your left. You can't use duress there. You don't have the right or the power to choose why your life is more important than somebody else's in this situation. This isn't me giving you a free out when I tell you to kill them or else you'll kill somebody else. I'll kill them, or, you go kill Jakai or I'm going to kill your mom. That's not the way that works. You don't get to go kill Jakai. Jakai could be the next doctor that solves cancer. He could be somebody else. You don't have the right to make that choice. Nothing in your life gives you the right to choose this person's life over that person's life when it's an instance of murder or something along those lines. So duress doesn't work in those cases. You also can't use duress for rape or really any other crime where there's going to be violence against a person. Go punch them in the face or I'm going to hit you. No, that doesn't work either. Let them hit you and sue them. Okay? Necessity. The last of these affirmative cases are necessity. All you have to do is think about disaster situations where the hurricane has come through, the tornado hit, the earthquake hit. There's no potable water. There's very little resources that you can use to survive off of, and yet there's a Walmart down the street that's out of business because they don't have power, they don't have anything they need, and everything that they have has got to be thrown out anyways. If you go into that store and steal 2 cases of water for you and your family so you can survive, that's necessity. You are doing something to preserve life. That's what necessity is. In Victor Hugo's Les Miserables, the concept was that Jean Valjean stole a loaf of bread out of necessity to save his sister's child because they were starving to death. In today's day and age, here in East Stroudsburg, that probably doesn't work so well. Stealing food, stealing drink, probably doesn't work in even in this environment of COVID-19. There are soup kitchens, there are food pantries, there are places people can go to get necessities. And so that necessity defense for something like that in a normal everyday situation doesn't fly. So Jean Valjean in today's day and age would still be convicted and have to deal with his crime of stealing a loaf of bread. But after Hurricane Katrina hit, after the hurricanes in Florida, after Hurricane Hugo hit in South Carolina, after these things, when people went in and took food, took drink because they needed it to survive, it's either that or die. They might be charged with a crime. They might go to court for the crime, but they're not going to be convicted if they can convince the judge or jury that their affirmative defense actually makes sense in necessity. So the first few defenses that we talked about when we talked about no crime happened, that there was actually no criminal act, or that you didn't commit the criminal act, somebody else had to because you have an alibi. Those are pretty easy to understand. But these ones, infancy intoxication, insanity entrapment, duress and necessity, they're a little more complicated, and it's important to recognize when they can be used and when they can't be used. Infancy is all about age, and really for most crimes it applies pretty well. Intoxication is never going to be a defense for rape or murder. You cannot use intoxication as a defense for drunk driving. I'm sure a lot of people have tried, and that doesn't quite work. It does work where there's no intent necessary. Insanity, again, we're talking about the when we're using insanity as a defense of a criminal act, that's at the time of the act. Entrapment, it's not just offering you the opportunity and you saying yes. Yo, dude, you want to try these drugs? Sure. That's not entrapment. Duress, there has to be an actual threat, and you cannot use duress to hurt somebody else. There's no defense for that under duress. That's just not cool. That's not fair. In necessity, it's never necessary to kill another. It's never necessary to rape. It's never necessary to assault. It's never necessary to hurt somebody else. But it might be necessary to steal. It might be necessary to knock down a wall. It might be necessary to break into a drugstore. It might be necessary, given circumstances that are completely out of your control. Those are the things that you have to understand. This is a real quick overview. This probably went about 10 minutes longer than I anticipated, but this is a real quick overview of these defenses in Chapter 11. And the quicker you can come to terms with what these are, the better off you're going to be. So, my suggestion for you, make sure you've done a study guide. You're going to do the problems out of Chapter 11. If I'm not mistaken, there's not a ton. There's, I think, 3 problems in Chapter 11. And then after this, we're going to spend a few days. I'll do a few of these for Chapter 12 because, like I said the other day, Chapter 12 is a beast. Everybody have a good day. Good luck. Stay safe. Stay healthy. Stay home. Wash your hands a lot. Don't bleach people, but bleach things. Talk to you later.